Stakeholders on alternative dispute resolution from African countries have gathered for a 5-day Gumzora ADR conference to discuss fast forward how alternative dispute resolution mechanisms can be embraced in African countries to reduce on-case backlog and to speed up justice to litigants in their respective countries. Day one of the conference was attended by judicial officers, African Chief Justices, mediators, arbitrators, lawyers from African countries, and retired judicial officers. At the opening of the conference, Chief Justice Dr. Flavian Zeija said, following the enactment of the ADR policy, cognizant of disputes that are community-based, ADR can be the best solution to such disputes to avoid piling of cases before the courts of law.
Courts don't resolve disputes. They decide the cases. That is why when a high court judge hands off a decision, the first thing the person says, I will appeal. Because some of these disputes that bring us to court can actually be solved by either, for example, if it's a family matter, it can be solved by a religious leader, it can be solved by elders, it can be, before you come to court.
Chief Justice Dr. Flavian also revealed that with the urgent need to embrace ADR, the judiciary has started to implement the alternative justice system strategies in different parts of the country. A case in point, the sub-region of Acholi, Lango and Buganda, and training of mediators and arbitrators.
None ever told us that actually a case can be resolved outside the court system. So we are trying to preach that gospel. We are trying to do a lot of training so that every person is on the same page. And then after that, we think that when everyone is on board, then very many people will be going for ADR.
President East African Chief Justices, Justice Nestroy Kayobere, noted that the ADR mechanism will enable efficiency and strengthen the development of justice and to solve disputes within member communities without fluctuation.
They allow for neutrality, confidentiality, and speed qualities that traditional litigation often struggles to match in a complex regional context.
Minister for Justice and Constitutional Affairs Norbert Mao held the view that alternative dispute resolution is the only way to go to speed up dispensation of justice to litigants.
When parties go to court and they say, I will show him who I am, then their focus is not even to solve the problem. It is about proving some point. Those we call stakeholders are, for instance, the people who have disputes. The other stakeholders are the lawyers. It is important that the lawyers realize that ADR is cheaper, it is quicker, and it is more flexible, and it is centered on the parties.
Mao, however, dismissed allegations that ADR can't serve justice.
But some people think that perhaps they are accused persons who simply admit guilt in order to get out of jail, whether they actually committed the offense or not. Now, that should be subject to case-by-case analysis. We cannot generalize. Plea bargaining is a good initiative that the judiciary of Uganda has initiated, and it is clearing our prisons.
The conference, scheduled to run for 5 days, will look at capacity building, masterclass on construction contract and adjudication of construction disputes, domestic arbitration and international arbitration. Deborah Namamonde, Viola Nansuga, UBC News.